everyone. Committee to order. And before we go to the roll call, Mr. Chairman, did you want to introduce our newest member to the committee? Representative Fritz.
To my knowledge, there's only one. Representative Jonathan Fritz, welcome aboard.
Chairman, thank you very, very much. Looks like an impressive cast of characters here. I'm pleased to be on board, and just want to extend a thanks for bringing me in a time where things are rather sedate and not too controversial. I could just ease right into things. So, yeah, thank you very much.
What you all don't know is I warned him last night that this was going to be contentious.
We always aim to please on this committee.
Yeah,
So,
well, your usual charm is smoothed away. Thank you, John.
Oh. Excuse me, I'm having trouble with my microphone. It's falling apart before my hands. First, we'll deal with the roll call. Christina, could you call the roll? Here.
Here.
Oh, vote by designation? Vote by designation.
Present? Designation? Designation?
Okay. I'd like to call on Chairman James to please lead us in the Pledge of Allegiance. All rise.
Flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
It is my pleasure.
With that, we will proceed with our agenda for today. The first bill to come up is actually my bill, House Bill 451. Is there a motion to bring the bill up? Hanbid, seconded by Donahue. Okay, the bill is now before us, and I'll call upon John Castelli to give us an overview.
Okay, House Bill 451, it's Chairman Freeman's bill, would establish the Tax-Exempt Property Municipal Assistance Act to provide financial assistance to eligible municipalities for the tax-exempt real property located within the municipality. The assistance would utilize the tax revenue generated by the liquor tax imposed pursuant to Act 4 of 1936, first special session, and referred to as the Johnstown Flood Tax. A municipality would be eligible for assistance if its total assessed value of tax-exempt property equals or exceeds 15% of the total value of assessed property within the municipality. And each county shall annually compile a list identifying the market value of tax-exempt property within the county. Also, the legislation would create the Tax-Exempt Property Municipal Assistance Fund, would be established in the state treasury as a special restricted account and used exclusively for the purpose of making annual revenue distributions pursuant to the act. All revenue derived from the liquor tax would be transferred to the fund by the state treasurer annually. Monies in the fund shall be distributed by the Department of Community and Economic Development by September 15th of each year. And monies in the fund are appropriated on a continuing basis to the department for purposes of making distributions under the act and shall not lapse at the end of the fiscal year. DCED shall determine annual sharing of the funds in accordance with the following. Each municipality's total market value of qualified tax-exempt properties shall be divided by the total market value of qualified tax-exempt property in all eligible municipalities with the quotient expressed in a percentage. Then that percentage shall be multiplied by the funds available for distribution to determine the amount of funding for each eligible municipality. Assistance would be subject to the following limitations. No municipality would be permitted to receive more than 10% of the total funds available for distribution. No municipality shall receive an amount exceeding $100 per person based upon the population during the last decennial census, and the amount of any in lieu of tax payments received shall be deducted from final payment under the Act and returned to the department and deposited into the fund for disbursement in the next fiscal year. And the department is required to adopt guidelines, written guidelines, necessary to implement the Act. They would have 180 days from the effective date of the Act. And finally, the bill would repeal provisions of Act 4 of 1936, which, insofar as it requires monies to be credited to the general fund from the liquor tax.
Thank you, John, for that overview. Just by way of background, this is a proposal I've had many sessions, and actually I've gotten out of committee twice. We've never gotten into a floor vote, but I think it's opportune now, as our revenue stream coming into the Commonwealth is rather robust and can allow for something such as this. It really would help all those communities, all those municipalities that have a very high percentage of tax-exempt property. Though to qualify, you only need at least 15% to be in the mix of municipalities that receive this revenue sharing. The ones who would benefit the most and are in need of it the most are Act 47 distressed municipality communities. Typically, they run anywhere from 25% of their total assessed value as a nonprofit, and some as high as 50 or more. Harrisburg has 50%. Johnstown has a high percentage as well. And Scranton has notoriously had about 30% or more of its properties as tax exempt. What has happened over time is a shift of where industry and commerce has gone. With the suburbanization of our culture, a lot of commercial activity left the downtowns and went out to the suburbs. A lot of industrial concerns left the downtown or closed and went out to the suburbs as well. What has resulted in a higher spike of nonprofits is that many of them locate in the communities that are more urban, whether they be a borough or a city. So for this legislation in particular, there would be a way to shoring up the tax base of many of our third-class cities, all Act 47 communities, which could probably get them out of being an Act 47 to begin with, as well as any county seat, if you have a courthouse town, any town that has a non-for-profit institution of higher learning, or any town that has a fairly sizable non-for-profit medical facility would all be eligible to receive additional financial support. There is a spreadsheet that was done by the Pennsylvania Economy League, and I apologize to our Republican colleagues. We tried to get it out to you. We had a glitch in transmitting it. There is one in your packet, though, today, so if you want to take a quick glance, you can see how the communities in your county would fare under this proposal. You know, when it comes to nonprofits, many of them are important regional assets to an area, whether it be a medical facility or whether it be an institution of higher learning. But the bottom line is they don't pay real estate taxes, and that's the mainstay of our local governments. This helps to compensate for that, to stabilize those communities, to make sure that they can continue to provide the kind of services that are expected at the municipal level. With that, I'd be happy to open it up to questions or discussion of any of the members. I think we have one on our list. Representative Rader.
My question is, what's the dollar amount that would go into the fund that would be taken out of the general fund?
Currently, the Johnstown flood tax money amounts to just under $500 million.
$500 million.
So we'd be distributing
So that is a concern of mine because, yes, we do have money right now. I don't know what our economic outlook will be in 2 or 3 or 4 years, and taking that amount of money out is a concern. Where I live, you know, we don't really complain about township taxes or county taxes, school taxes, and this doesn't really address that portion of it. So for my particular district, I'd be concerned about 2 things: what we take out of the general fund, and also you know, who's getting the money, the school districts or not. So that's a concern of mine.
Although in Monroe County, I believe both Stroudsburg and East Stroudsburg would benefit because of the university.
They probably would, but
and
that's
because of the
not my
courthouse.
district.
Yeah. But take a look at your spreadsheet.
Yeah, I didn't see the spreadsheet. I didn't know that. there was
It
one
should be in your packet. Again, my apologies to the Republican members. We tried to send it last night and we ran into
there.
a
Yeah, I didn't
glitch.
see it. Okay,
But it should be in all of your packets if you want to glance at your
thank you.
your communities. We also have The executive director of the Pennsylvania Economy League is also here. They helped to prepare the spreadsheet. Would you care to come up and just give us a sort of overview? Thank you. And please introduce yourself to the members.
Good morning, everybody. I'm Vinny Canizero. I'm the executive director of the Pennsylvania Economy League. We went through and put the spreadsheet together. I will say there is a wide range throughout the Commonwealth of municipalities and the level of tax-exempt properties that are included and that they have. It ranges from some 0% in some municipalities to over 90% in others. It is a range of the size of municipalities, the classifications, the amount of tax exempt and taxable property that is within the municipalities. But again, if you go through the spreadsheet, you'll be able to see a rather direct indication of what each county and where your districts are and the amount of money that would go into it. A couple of things to keep in mind. In the legislation, it does say that municipal and government buildings are excluded. We have not excluded it from this number for a couple of reasons. One is that the assessments of each county is on this piecemeal process that can be difficult to compare apples to apples against each other. Some counties will say this is government and make that designation, while others will not. The larger question around it, though, is what do you do with those properties? If a municipality is in financial distress, they may sell that asset, and that's really a large reason why, at least from our perspective, it should be included in the total amount of tax-exempt properties because it can be sold rather quickly for a cash amount. I am happy to answer any questions that anyone may have. I also do, which is not in your packets, but a breakdown by county, a breakdown by municipal type, and also a breakdown by population size. So I'm happy to answer any questions, and Representative Freeman, Chairman Freeman, yeah.
Thank you so much for this. I'm looking at my county, and under a couple in Chester, and I think in some of the other southeastern counties, it just says occasionally township or borough. It doesn't actually name the municipality.
That is most likely just how it came out when it was printed. I can send out an updated, it is a lot. It's 46 pages. I try to condense it so it would all fit on one page, but I'll make sure to send out the spreadsheet to everyone so you all can have the exact data and the raw data.
We did have an earlier spreadsheet, too. You might want to just compare.
There
that.
are, yeah. So there, this is, and Chairman Freeman, I don't know if, when that spreadsheet was initially created. It is, from our understanding, was in the mid-90s that it was created. It could be in the mid-2000s. I think there's a bit of disagreement about when that was. Regardless, we're seeing a lot more municipalities exceeding the 15% threshold than we did in previous iterations. Why that is, I don't exactly know yet. We are digging into that a bit more. It could be a factor of economic development in that there are either more or less taxable properties, or there is an increased need for services throughout the municipalities, and there is an increase in tax-exempt properties. So you will see some municipalities have had a decrease, and others have had a pretty substantial increase over the last, I'll say, 20 to 30 years.
Yeah. Again, if any community is in Act 40 distress status, if it's a county seat where the courthouse complex is, or if it's a place where there's an institution of higher learning that's operating, or a non-for-profit hospital, all of those would probably increase the percentage of tax-exempt properties within their boundaries. I should note, too, this isn't something geared just for the big cities. The poster children for this bill probably are Clarion, where there is a university, and also Gettysburg, where you have a battlefield, you have a hospital, you have a college, and you have other tax-exempt properties that really kicks up the number of percentage for the communities such as Gettysburg. Just ask Dan Moll, the representative from Gettysburg. He can attest to that.
And what is, from our perspective, what is really important about this legislation is the diversification of revenue for those municipalities. A lot of our smaller boroughs and townships, even though there is a high number of tax-exempt properties, that does not mean that those non-tax entities do not need services from the municipalities. So this is providing an opportunity for tax-exempt organizations that either don't provide pilots, which there are a good number of them throughout the Commonwealth, or that are exceeding or using excessive services regardless of their contribution to the municipality. So fire and police and whatever else it may be, this is really filling an important gap for those individuals and for those communities.
Thank you. Any questions of any before we move on? Lisa? I'm sorry, Representative Borowski.
Yeah, please.
Does this include, so the final number you have, does that include all nonprofits? So you don't know which one is giving a pilot and which one isn't? So, okay, all right, thank you.
So we receive this data from STEB, and they did not give us any designations of what the tax-exempt classifications were and what the different categories were. We just have a solid number of tax-exempt properties.
I should note, too, that if there is a pilot in play and they continue to provide funding for that pilot, that would be deducted from the amount that the state would be giving them. They won't be able to double dip. Representative James, Chairman James.
Thank you, Mr. Chairman. I agree that the issue at hand is one of significant difficulty. In the 20th century, I doubt if legislatures ever thought we'd get to this point where so much of the property is tax exempt. So is a solution necessary? Sure is, but I have a bit of a problem with this particular one. Anyone who's ever lived through a general reassessment of their township, their city, their county perhaps, knows what a nightmare that is. Basically, it comes down to a third of the people don't change, a third are mad as get out because they've gotten increased, and a third are very happy because somehow or other their taxes went down. This is called for almost, the requirement is to report to DCED annually on the assessment due to market value of the homes, which is obviously a moving target. Every time somebody changes residences or what have you, assessed values could change. So I have a problem with that in the accuracy of the distribution. I do see my hometown does all right in this, but out of approximately $465 million of Johnstown alcohol tax, $500,000 doesn't seem all that much. Anyway, my other problem is the $465 million has been part of the general appropriations for many, many years. I guess, I don't know, the 30s?
Since the end of the Johnstown flood.
Yeah, whenever that was.
Once the funding for that was used for the Johnstown flood and that disaster was no longer an issue, it was just put in the general fund.
And so as Representative Rader has pointed out, yeah, we're okay today as far as revenue flow, but what happens 2 years down the road, 3 years down the road? How do we fill that $465 million gap in the general appropriations? And so for those, my two reasons, I'll have to be a no on this bill.
Okay, thank you for your comments. The issue of reassessment obviously is an important one, but it's almost separated from this because we're talking about acknowledging what properties are tax exempt and therefore aren't paying taxes. You touch on a very good point about reassessment needing to be done, and it always has mixed results. But that really is apart from what we're dealing with here today. I appreciate the concern over diverting funds from the general fund into this effort, but I would say two things. First, this revenue cycle has shown us that we are very flush. We even have reserve funds in the rainy day fund, which are exceeding levels that we could never have anticipated a long time ago. We have to consider the communities of our Commonwealth, too. Many of them now have a flood of nonprofit entities within their jurisdiction that simply do not pay real estate taxes. And that is the mainstay of almost all municipalities in the Commonwealth of Pennsylvania. They are great regional assets, they're employers, they provide a very important service in most cases to the community. But in the absence of real estate taxes, we are asking every host municipality to just bear the burden. And this is a way of relieving that burden. As far as the total sum of money being transferred from the Johnstown flood tax into this tax-exempt property municipal assistance fund, I'm sure as this works its way through the legislative process, there'll be adjustments to that. There may be a desire of only having a portion of that go to a cause such as this. But without it, I think we're going to continue to see many municipalities fail. And they'll continue to go into Act 47, which means the state does begin to take on some responsibility in terms of how we deal with them. This can stabilize every community here in the Commonwealth of Pennsylvania, but particularly those who have a huge amount of tax-exempt properties. In doing so, we leave them in a better shape to provide essential services, and we make sure that the state is not going to be intervening in an Act 47 way that might not lead to a positive conclusion after going through that process. So for those reasons, I would urge the members to send this to the House. Let us have a full, more robust debate on the floor of the House and consider amendments that might come up. Oh, Representative Probst.
Sorry that I was late. I'm a proud supporter of this bill. And as a former mayor of Stroudsburg Borough, the county seat of Monroe, as we say, you can't swing a dead cat without hitting a church. It's so easy to get a nonprofit status. And when you're landlocked, your tax base just keeps going down, and it's more expensive for the residents that live there. So when I hear comments that, well, you know, we're just not going to have it at the state, you're actually going to have more, because by doing this, you're going to have people be able to spend more in the economy, to be able to, you know, flourish better in their communities, less grant applications. So it's actually going to benefit Pennsylvania by helping out in these situations. So with these reasons, I'm a full supporter of this bill, and I'm asking that everyone else vote yes as well. Thank you.
Thank you for your comments. Are there any other comments or questions to be asked? If not, I'd ask Christina to please call the roll. Oh, I'm sorry, did we have another one? Sorry. Oh, sure, Representative Wayne.
Yeah, I'll ask a real quick question. So this bill was voted out of committee in, I think, 1920?
I'm sorry, can't hear you.
Yeah, so this bill was voted out of committee in 1920, I believe? Legislative session?
The flood tax came into being in 1936.
Yeah, I don't know if that's, like, I don't know. Yeah, so
sorry?
let me restate the question.
Okay, sure.
It appears that this bill has been considered in the past in this committee and has been voted out of committee
Twice.
As you mentioned, how does this version of the bill differ from the one that was voted out of committee?
With a few minor tweaks, it's exactly the same. I think I know where you're going with your question. In those days, we had deficits. The state was not robust in its revenue, and so it was always difficult to get this across the finish line. But given the kind of revenue we're seeing now, I think it's an opportune time to offer this to help our cities and boroughs and townships that do in fact have a high percentage of tax-exempt property. Any further questions? Did you have a further? Okay, thank you. Any other questions? Anything for discussion? Okay, if not, I'd ask Christina to please call the roll. Yes. She's here. Oh, vote by designation, yes. Vote by designation, yes. Vote by designation, yes. Vote by designation, yes. Vote by designation, yes.
No. Designation, no.
Okay. The bill having been approved by 14 of the members, the bill will be reported to the floor for further action. Thank you. Our next legislation is Representative Borowski's House Bill 1442. John, could you give us a brief overview?
House Bill 1442, Representative Borowski's bill. This bill would amend the Water Services Act, that's Act 28 of 2006. Under that act, certain cities of the third class have to receive specific approvals when terminating a municipal authority that provides water or sewer service to municipalities outside the city. And under the act, when seeking to privatize a water or sewer authority, such cities must obtain the approval of 75% of the municipalities which have service agreements with or whose residents previously received water or sewer services or both from the authority prior to the termination of the authority. Alternatively, under the act, if such cities intend to continue water or sewer services previously provided by an authority to surrounding municipalities, it must receive approval from the Public Utility Commission prior to the termination of an authority or the conveyance of a project or the transfer of reserves, assets, or funds from the municipality to the city. House Bill 1442 would change the definition of the term city under the act to include cities of the third class that have adopted a home rule charter and have a population of 30,000 or more. Under the act presently, the definition of a city is defined as a city of the third class that has adopted a home rule charter and has a population of not more than 30,000. And also under the bill, the term authority would be changed, under the definition of authority, would be changed from municipal authorities that provide water and sewer services to authorities that provide water or sewer services.
Okay, thank you, John. I neglected to ask if there was a motion to bring the bill up. Representative Sappi, second. Representative Borowski. There is an amendment to the bill, and John, if you could give us an overview of it. Is it the First Amendment or the second one?
The first one.
Amendment 4489, offered by Representative Madsen. Do we have a motion to bring up the amendment?
Madsen made the motion.
Oh, you did, I'm sorry. Madsen made the motion, and who was our second? Oh, Representative Fleming, thank you.
This bill would, this amendment would extend the applicability of the bill to all cities of the third class. So the definition of city would be changed to include all cities of the third class, regardless of whether they're home rule.
Any questions or debate? On the amendment, that is. Yeah.
Rader.
Oh, Representative Rader.
Still don't have a mic, but
Oh, I'm sorry.
my concern with the bill and also with the amendment, especially with the amendment since it expands it, generally what I've seen happening a lot of times with municipalities, they don't want to raise rates on their customers and the people who vote for them. So they keep the rates artificially low and don't do fixes and capital expenses that they should do in their system, so the system gradually deteriorates. And because it's artificially low, the surrounding communities are happy that they're not paying maybe a rate that they should be paying because it's been kept artificially low. So what I see happening a lot of times, those communities, when it gets to a point where they really can't handle what's happening with the water system and they don't want to raise rates, they sell to a water company. Well, the water company comes in and they say, well, we have to do all these capital expenses, so we're going to have to raise the rates. But it's not on the political people who've kept it artificially low for all those reasons. The new people coming in have to raise the rates because they have to do capital expenses. Well, why would any surrounding communities vote knowing that someone else is going to have to raise rates? Why would they vote for a sale? They wouldn't do that. So I think this is a dangerous bill only because I think the townships and municipalities aren't doing the right thing with the water system. They're keeping rates artificially low. The new people come in, have to raise the rates. Everyone knows they have to raise the rates, and that's why they get a bad name when they come in, but they're doing what has to be done to fix the water systems. So I don't think surrounding communities would vote for that sale, and it could actually hurt water systems in the long run because these capital expenses have to be done. So because of all those reasons, I'm against this amendment expands those opportunities, and I'm against the bill also because of those reasons. I think the way things actually operate are not the proper way because people vote for the people who are deciding what the rates are, and they don't do that when it's a public company coming in to do the proper amount of work on the system. And so they get a bad rap, but they're also doing what has to be done to keep the water system operating properly. So
I appreciate the gentleman's comments. I would only say that if they were not able to sell to a private water company, as was the intent here with this legislation, the public water company would have to bite the bullet and increase the rates to actually attend to the needs of the water authority. And so I think that would be addressed at some point in time. The thing we're seeing, and I'll turn it to Representative Borowski before I come back to Representative Rader. The thing that I think is driving a lot of this is that water companies come in, they overpay what they are willing to pay for a acquisition of a public water facilities, and then the rates get jacked up sky high. That's a trend we're seeing in the Southeast in particular. But Representative Borowski, since this is your bill, did you have a comment you wanted to make? I know.
I guess I was just trying to understand what the statement is. So is it if the municipalities all vote and decide that the sale can go through, the maybe one municipality that doesn't would be penalized by the water company? Is that what you were
No,
suggesting?
not the water company. What happens is municipalities a lot of time don't do the capital expenses they're required to do because they don't want to raise rates on their customers because they're voted into positions. So they let the systems go downhill for long periods of time. Then they get to a point where they can't handle it anymore, and then they look to have a water company come in and purchase it. And I've seen that, you know, they can purchase it for X amount or X plus amount. A lot of times the municipalities want to get as much money as possible, so that they overcharge the companies, and then they have to raise the rates even more because of that. So I've seen both sides on this thing, but I do know that municipalities a lot of times do not do the capital expenses they're required to do, and then they get to a point where they have to sell it, and then the water company comes in and does the proper capital expenses, and they have to raise the rates. So I see that part of it, and that's what happens. Should they do the capital expenses? Yes, they should, but they don't, and a lot of times they wait till it's too late, and then they want to dump the system because they can't afford to do the proper upgrades, and if they do, they're going to have to raise the rates too high, and they do get voted into office, and they don't want that to happen. So that's what happens that I see happening in my area, and so I think because of that, I think there's a dangerous precedent to make for that, because what's happening now is not right, and the water companies coming in are doing the right thing by spending those capital dollars, but then they also have to raise rates, and that's not popular.
So I don't think this bill disputes that, you know, if a municipality decides to sell to a water company, and they want to come in and make those changes, if the municipality, you know, feels like that's something necessary that they have to do. This bill isn't preventing anyone from doing that. It's giving all those who are receiving the service the opportunity to participate in that process, for there to be some local control around that process. And I think then, you know, it will be, if this is, so it already is enacted for certain third-class cities. It would just require, I think, then a better coordination between the municipalities that are served by the existing water authority. So if that is something they all want to do, if they all want to go forward with that, then they would need to work on that and make that decision together. But it would also give, I mean, to me, this, you know, as a former commissioner in my township, you know, one of the things that we valued the most was having local control and hearing from your residents on what's going to happen to them. So that is what this change, it brings more opportunity for people to participate in the process. It allows for, you know, the elected officials to be accountable to the people that they are serving. It provides, I think, an opportunity for the water companies to also engage. You know, right now, if one municipality owns the facility, but others are being served by that, is that information, you know, are the water companies engaging with the other communities that are being served to understand what their concerns are, what their needs are at the beginning of the process as opposed to the end of the process. Also, I think this, you know, while the PUC and that process is helpful when it comes to this, you know, sometimes talking to the PUC is like screaming into a black hole. You know, if I'm a resident in a community that's being impacted and you're told, go and talk to the PUC about this, that is a very frustrating process. It is much, I think it is a much better way to move something forward in a community with municipalities, to have residents talking to their elected officials making the informed decision, and then, you know, also engaging with the water companies if that's the way they decide to go. So let's start that at the beginning of the process let's not start that at the end and wait for people to just accept the fallout. So to me, that's, what this change means. It's not like it doesn't exist in other places. I think my colleague who will be, I think, expanding this, Representative Madsen, will be expanding this so that more cities more municipalities have the opportunity to participate. This, to me, is about local control. It is about transparency, and it is about residents having a say in what is going to happen, and elected officials who are elected to serve their communities making those decisions.
I do want to recognize Representative Madsen. It is his amendment that we have before us.
Appreciate that. Just for the benefit of the committee, why I introduced the amendment and just sort of where I'm coming from, particularly as it pertains to my district. So here in the city of Harrisburg, we have Capital Region Water, and Capital Region Water services not just the city of Harrisburg, but it does the surrounding municipalities, which includes Pembroke, Paxton, Steelton, Susquehanna, Swatara, and Lower Paxton. I have the privilege of representing both Paxton, Steelton, and Swatara. And a few years ago, it was a real thing when I was in Harrisburg City Council, the Pappenfuss administration was attempting to sell the water authority. And so, well, that's well and good if they wanted to try to sell it. I always thought it was sort of deeply unfair that the other municipalities weren't being engaged or had an opportunity to chime in. And now I represent those municipalities. If there were interest in selling the water authority, I know that constituents would want to have a say in the process, and it would deeply affect our district. So Harrisburg has yet to go through a home rule charter, so the amendment was just in case this were to occur again, that we could allow more local municipalities to have a say in my district.
Okay, Representative Rader, if you could be very quick because we have a full agenda.
Yes. Well, I also like local control. I think this kind of takes away the local control of the municipality who actually owns the system. And why would a surrounding community agree to a rate increase, which they know will happen if the water company is sold? They wouldn't want to. So it's going to harm them in the long run because the systems will continue to deteriorate. The local communities don't raise the rates properly. They don't take care of the water systems the way they should. A lot of times they don't do those investments. So that's why.
I appreciate that. I'm not sure that's true in all cases, but I appreciate your perspective. Chairman James, and then we do have to move on to our agenda.
Okay, very quickly, to the maker of the bill, I guess. 75% of the people affected by any kind of a change here have to agree to that change. Is that correct? How do you get to that number? Is it a referendum, or is it decided by the townships and boroughs surrounding?
It's surrounded by the townships and boroughs that are served by the water system.
Okay. So a handful of men and women elected to office will be making a decision for the 100%. Thank you.
I would
Thank
argue,
you.
isn't that the way it usually is?
Okay. Well, I appreciate the discussion we've had so far. I would like to have us move to the amendment if possible at this point. Did you have any points you wanted to make about your amendment, Mr. Representative Madsen?
No, I just wanted to give the real example on how it affects my district. Thank you.
Sure. Okay, that being said, I'd ask Christina to please call the roll, sorry, on the amendment. Yes. Vote by designation, yes. Vote by designation, yes.
Yes.
Vote by designation, yes. Vote by designation, yes.
No. By designation, yes. Wait, is he here? Oh. Okay. By designation, no.
The amendment having passed will be added to the bill. We now turn to the bill in chief. Is there any discussion on the bill in chief, or should we go to a roll call? No discussion? Okay, Christina, I'd ask you to do a roll call on the bill in chief. Yes. Vote by designation, yes? Vote by designation, yes? Vote by designation, yes? Vote by designation, yes.
No. By designation, no.
Okay. The bill having passed will be sent to the floor for consideration. Just going to depart slightly from our current agenda. I know we have two bills by Representative Siegel. We do want to hear from him today. But I'd like to move on to some bills I think we could probably move quite quickly given the hour that we're at. The next bill in question is House Bill 2147 by Representative Fleming. John, will you give us a brief overview?
House Bill 2147, Representative Fleming's bill, would amend the Municipality Authorities Act, Section 5607, Purposes and Powers, which is found in Chapter 56 of Title 53 of the Consolidated Statutes. The bill would require the Commonwealth and any of its departments, boards, commissions, or instrumentalities to pay stormwater management fees levied by a municipal authority for property owned by the Commonwealth and its various agencies and instrumentalities. Further, the bill stipulates that a tax-exempt entity shall not be excused from paying stormwater fees solely based on its tax-exempt status. The bill also clarifies that the rates imposed by an authority that performs stormwater planning, management, and implementation may be based in whole or in part on the property characteristics, which may include the property's impervious surface as determined by the authority, or the installation and maintenance of best management practices approved and inspected by the authority. The bill stipulates that all properties containing an impervious surface are presumed to benefit from an authority's stormwater planning, management, and implementation. And finally, the stormwater management rates, that stormwater management rates may be charged by one or a combination of the following methods. One, on all properties located in the service area of the authority. Two, on all properties that are served by or benefit from a specific stormwater project or plan. And or finally, by establishing a stormwater management district and charging the rate on the owners of all the properties within the district.
Okay, is there a motion to bring up the bill? Moved by Probst, seconded by Donahue. The bill is before us. There is an amendment to be offered as well. If you can give us an overview of the amendment. It's 04429, and I am the prime sponsor.
Okay, the amendment is, would add a new Chapter 33 entitled Stormwater Management and language into Title 27, Environmental Resources of the Consolidated Statutes. This amendment provides legislative findings on the adverse effects of inadequate stormwater management. It establishes the Commonwealth's duty in statute to pay stormwater fees levied either by a municipal corporation or a municipal authority. It affirms the same duty for tax-exempt entities, and it adds definitions for the terms impervious surface and stormwater for consistency between the different consolidated titles and to provide a foundational definition for future policy on the issue. So this amendment really would be covering, as the underlying bill is only addressing municipal authorities that levy stormwater management fees, this language now, including in Title 27, would cover all municipal corporations that are presently authorized to levy stormwater management fees or may be in the future.
Okay, a motion to bring up the amendment. Representative Fleming, seconded by Representative Hambidge. Representative Fleming, would you like to talk on the amendment?
Yes, sir, very briefly. Thank you, Chairman, for offering the amendment to, extend this opportunity and to bring the, bring more clarity to what we're trying to do here. So thank you. I encourage an affirmative vote.
Thank you. Representative Kuzma, did you want to speak to the amendment or the bill in chief? Okay, then we'll take the amendment up first as a vote. All those in favor, please signify by saying aye. Are there any negatives? Okay, the Motion carries to include the technical amendment. We are now with the bill in chief, and I will recognize Representative Kuzmin.
Thank you, Mr. Chairman, and thank you, Mr. Fleming. So Representative Fleming and I get along very well because we were both commissioners in a first-class township. So we have that in common. And I realize that the MS4 mandate is a major problem for municipalities because it's another unfunded mandate. It costs millions and millions of dollars across our Commonwealth. And I think that we need to address the unfunded mandate by either removing the mandate or appropriating funding towards it. I have an issue with this bill because I think that it is unconstitutional. It is unconstitutional because we are unnecessarily, and we don't have the authority to, appropriate the ability for us to appropriate funding to lower forms of government. So if this bill were to go through, we would have to build an addition onto our house to accommodate all of the unelected and appointed authority board members so that they could vote on appropriating state money. That is what we were doing. Because instead of a authority needing funding, coming to us, applying for it, and we appropriate it, they were appropriating it to themselves by taxing a higher form of government. So we have an issue of it being unconstitutional because we are delegating our appropriation authority to not a lower form of government, but an unelected board. And on top of that, we are sovereign. We don't have the ability to be taxed, as the Commonwealth Court stated last year. We don't have the ability to be taxed by a lower form of government. So we are trying to solve a problem, which is a major problem, but we're doing it in a way that is unconstitutional because we are violating our own sovereignty and we are giving the authority for a lower form of government to appropriate state funding. So that's why I'll be a no.
Just to clarify, the federal government does pay the fees. It's only the state that would quibble about that matter. And I would keep in mind that this is a fee, it's not a tax. That's obviously going to be a decision decided in the courts based on the Westchester case. But a user fee is for what you use and or what you contribute to help address a certain issue. The federal government does pay for stormwater fees with no concern. Obviously, that's an even higher jurisdiction. But I think there's a distinction between a tax and a user fee. And that's the point of difference, I suppose. Representative Fleming.
Very quickly, so I will make this brief. I grew up playing baseball, and in my opinion, the Commonwealth is on its third strike, and let me explain. So the first strike is the Commonwealth has imposed these regulations, and the federal government, to be honest. EPA and DEP have imposed these regulations, and we need clean water. There's no doubt about it. We certainly need to protect our watersheds and protect the people who drink water. There's no doubt. But they impose these regulations and the regulations to clean up our watersheds and under the threat of massive fines. So that's a huge potential cost to taxpayers. That's strike one. Strike two, they offer, as Representative Kuzma said, and I respect you a great deal, they offer little to no assistance in helping municipalities build out their stormwater infrastructure or make improvements, or make the improvements that we need to do in order to clean up our watersheds. That's strike two. And number three, a refusal to pay their own fees. That we do, I disagree. I think we do have the authority in a fee structure, not a tax structure, but a fee structure, to impose fees on Commonwealth entities. As Chairman Freeman said, I mean, right in my district in Susquehanna Township, just up Cameron Street, the massive United States Post Office on Elmerton Avenue or in Crooked Hill Road pays its stormwater fee, but the Pima building does not. The Fish and Boat Commission does not. The state police headquarters do not. So, so in my view, 3 strikes and you're out. Obviously, this is still being litigated, but that's the reason why I bring this bill forward. And I just want to thank my co-prime sponsor, Representative Madsen. We both have, gotten alignment on this through our local government experience. So thank you, Mr. Chairman, for bringing this forward today.
Sure.
And I encourage an affirmative vote.
One other point to be kept in mind, I appreciate the argument that Representative Kuzma has made, but by this very piece of legislation, we are granting the authority to a local entity to levy its fee on the Commonwealth. So we are acquiescing in saying, yes, the Commonwealth should pay its fees. Without the legislation, you might very well have a good constitutional point, But I think since we are more or less delegating that right back to the authority, it's in keeping with a reasonable constitutional approach to how fees are levied. I'll recognize you and then
Okay,
Representative.
yeah. So I realize that the MS4 funding is a major problem, okay? So we can either roll it back or we can fund it through an appropriation. But I have a problem with an unelected person coming into this building, and instead of applying for a grant, and we have the authority to award it,
Right.
they come in and they apply for it, and then they just award it to themselves.
Well, if the fee were not to be a reasonable fee in keeping with the needs of the authority, I'm sure that the state could go to court with the authority as well to argue that point. Yeah, there are various remedies. Representative Rader, and then we'll have to move on to the vote.
I'll make this brief, sorry talking so much. My concern, once again, is what's it going to cost us in our budget? We already spent $500 million here. Is it going to cost another $500 million? All of a sudden, we're going to be paying fees we're not paying. And I will say, I had a water system put in my district from the feds. They came in, the state said, you have to get this permit, that permit, and this permit. And the feds said, oh, no, we don't. So governments don't have to, they don't always have to pay fees. The feds did not there.
I know, just in this case, the federal government does pay the stormwater fee. Okay, that being said, I'll ask Christina to call the roll. Yes. Vote by designation, yes.
Yes, I'm back.
Oh, I'm sorry, you're back. Okay, sorry. Vote by designation, yes. Yep, yes. Vote by designation, yes. Vote by designation, yes. Vote by designation, yes.
No. By designation, no.
The bill having received a majority vote of the committee will be reported to the floor for consideration. That brings us up to Representative Hanbidge's bill. John, do you want to give a brief overview of the bill? Is there a motion to move the bill? Moved by Mr. Donahue and seconded, seconded by Representative Fleming.
House Bill 2166, Representative Hanbidge's bill, would provide for a reduced fee schedule for the next of kin requesting autopsy, toxicology, inquisition, and coroner's reports. The bill would amend the county code so that a coroner may charge no more than $100 for an autopsy report, $50 for a toxicology report, and $50 for an inquisition or coroner's report when requested by the spouse, child, sibling, or parent of the deceased. And presently, under the code, it stipulates that the coroner shall charge $500 for an autopsy report, $100 for a toxicology report, and $100 for an inquisition or a coroner's report, and there's no provision for the next of kin to have a reduced rate.
Okay, there are two amendments. The first is amendment under my name, which is of a technical nature. Anyone care to move the amendment? Representative Hanbidge moves the amendment, seconded by Representative Probst.
The amendment, A04468, is a technical amendment. It would make the bill an amendment to Title 16, Counties of the Consolidated Statutes. As you recall, the county code is now in consolidated form. The governor signed it recently. So this would put it line up with that. And it would also add to the definition of guardians of the deceased as eligible.
Okay, any discussion? Seeing none, all those in favor of the technical amendment, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. We have another amendment offered by Representative Brett Miller. Is there a motion to take up the amendment?
So moved.
Moved by Chairman James, seconded by, I see a finger up, but I'm not sure if that's, oh, okay. Oh, Representative Kuzma? Sure, second. Okay, John? Oh, I'm sorry, Rob, do you want to give an overview?
Representative Miller's amendment A04535 inserts the language that the reduced fee is only applicable to family members or families making less than $45,000 a year.
Okay, any discussion? Representative Miller, I'm sorry.
Thank you, and thank you for your consideration of this amendment. Basically, the thought was this: if in these situations, they're tough enough as it is, but if you had two people coming in requesting this report, and one was a multimillionaire and another one was a person in low poverty, it didn't seem appropriate. And so I thought that in this case, it might be appropriate to implement some sort of measure, and I chose the rent rebate threshold as a standard that could be used in measuring this type of provision. But in light of the circumstances, I put this together, I think, rather quickly. I do think it has merit, something that we should consider in light of a disparity of income levels that might come in for this provision. And we'll withdraw it at this time and maybe work on it for the floor.
The chair thanks the gentleman. What we have before us now is the bill in chief. Properly moved and seconded. Does Representative Hambidge wish to make any comment?
Absolutely. So I met a constituent in my district whose daughter committed suicide, and she has a lot of grief surrounding that for obvious reasons. When she went to get the report, which previous to a law change, I think in 2019, would have been at a much less rate for her, lower amount for her to get, she was told she needed to pay $700. She feels that for closure and to really know what happened to her daughter, these reports, which are already made, and it's just the process of making them available to her, would help her find closure, and she can't afford $700 to learn what happened to her daughter. I think that when we were changing the rates a few years ago, we didn't envision this as something that we would be imposing upon people, and I think that this is a revision that would really help a lot of families seeking closure following the death of loved ones.
Thank you. If there's no objection, we'll take a voice vote. All those in favor, please signify by saying aye. Aye. Any opposed? Okay, the bill is passed unanimously and will be sent to the floor for consideration. We do have Representative Siegel here, and he's very patiently waiting to talk about his legislation. We do have two commission bills, however, I want to try and move. If worse comes to worse, we will take up your bills at the next meeting of the committee, which is coming up in, I believe, 10 days. So, but we could also hear from you if there's enough time to have comments as well.
There won't be.
Oh, Dave and Chris, do you want to come up to discuss the bills? There are two bills. They deal with different issues, but in the interest of time, if there's no objection, we could make a motion to take them both up and vote them as a package, if that's okay.
Great.
Is there a motion to bring up the bills? Representative Miller and seconded by Representative Sappy.
Chairman Freeman, Chairman James, thank you. I'm Dave Green with the Local Government Commission. We are entertaining two commission bills. Senate Bill 887 would amend Title IX, which deals with burial grounds, to treat municipal corporations on the same footing as we do for unincorporated associations, fraternal organizations, and churches for purposes of managing burial grounds. As you may all be aware, the municipal codes provide for neglected burial grounds to be maintained by municipal corporations under specified circumstances. These costs are borne by the taxpayers. There is limited public access to these burial grounds, and there is some ambiguity about whether or not the burial ground lot maintenance fund requirements within Title IX apply to municipal corporations or not. Are they, quote unquote, in the business of running a burial ground? This was actually raised as a matter of a township resolution from PSATS, from Plumstead Borough. And it was a very, very unique situation where the municipality had acquired a burial ground. and was still selling lots. I should be emphasized, in the majority of situations, this is not the issue. Most municipalities just maintain them. They mow the grass, they make sure that the access, they're respectfully treated. However, this ambiguity of the law by virtue of a PSATS resolution is something we felt appropriate for the commission to take up in a bipartisan, bicameral manner and address via statute to remove municipal corporations from the Title IX Burial Ground Maintenance Fund requirements and the certification. You may recall a couple months ago we had Representative Brennan's bill, House Bill 1730, which is currently in the Senate Local Government Committee, which actually addressed the other bookend of this issue, which was the state real estate property certification law, which also included tandem language. So we're actually closing off both ends of this particular loophole. We did pass an identical bill to this because, as you're aware, the commission passes companion pieces in the House and the Senate, and we had referred out House Bill 1641, Representative Mao's bill, was reported unanimously out of this committee on December 13th, 2023, accomplishing the same thing. So essentially, the bottom line on this bill is that we are treating municipalities as we would treat fraternal organizations or churches in the context of their administrative requirements for running a burial ground. And Chris and I are here to answer any questions if you have them.
Any comments? Seeing. Well, could you go over the other bill as well, since we're taking them as a package?
Thank you, Mr. Chairman. The other bill is Senate Bill 749. You may recall Chairman Freeman's bill did something very similar in terms of harmonizing the first-class township code revision that the commission did, I think, about 5 years ago. A provision of that revision included a protection for municipal governing bodies who rely on the opinion of their solicitor. Currently in the municipal codes, if an elected member of a governing body does something that is illegal, the elected Board of Auditors, under specified municipal codes, principally the township codes and the borough code, have the ability to surcharge, at the time of their filing the report, the members of the Board of Supervisors personally, not through taxpayer money, personally, for any illegal expenditure of money that causes a loss to the township. Now, that's essentially a term of art, okay? There is case law on the books, Kotler v. Warminster Township, which has a disturbing feature that says that even if they rely on the opinion of the solicitor, that what they're doing is legal, they could still be personally on the hook. Now, I think everybody on this committee is acutely aware of the difficulty we have getting people to serve in local government. And we also know the painful stories about members of governing bodies who don't ask the advice of their solicitor, who essentially take a run at difficult issues that sometimes get them into trouble. This innovation for the first-class township code, which in this bill, Senator Dush's bill, would amend the second-class township code to provide, says if there is a publicly disclosed opinion of the solicitor on a particular expenditure or a written opinion, okay, the publicly disclosed opinion has to be read into the minutes, okay, has to be reflected in the minutes. The written opinion has to be publicly disclosed. If those two things exist, then the public official is shielded from any surcharge by the Board of Auditors because they're doing what they're supposed to do. They're relying on the opinion of the solicitor and their legal judgment. There are other professional responsibility ramifications of that for the solicitor if we get to that point. However, beyond that, there's another innovation here. Chairman Freeman's bill, Act 3, amended the third-class city code, Act 3 of 2024, to allow cities to provide more flexibility in the provision of management services, to allow corporations, institutions, firms, LLCs to be able to provide management services on a part-time basis, okay? Provide additional flexibility. As you're mostly aware now, managers are hired as full-time employees of the municipalities, and the compensation's all over the place, but they are essentially professionals that are hired as employees by the municipality. This innovation allows municipalities to exploit a bench of an association because municipal law is multifaceted: land use, human relations, public services. So that is the other feature of the Dush bill. We've got the surcharge protection and the manager provision that allows by contract for LLCs, associations, and other entities to provide management services. And Chris and I can answer any questions that you have at this time.
Chairman James.
Thank you. Thank you for your testimony, too. Just to be clear, and maybe you already said this, if an issue develops and one elected official is actually determined to be guilty of a criminal offense, he or she is not protected by this law.
That's exactly right, Mr. Chairman. This language itself, and you can see from the bill in front of you, says if there is criminal collusion on the part of the official and the solicitor to try to game this language, they don't enjoy the protection anymore. And there are provisions, as you alluded to, within Title 18, the Crimes Code, that address this type of situation.
Point well taken. Any other questions? We've done this, as you mentioned, for other classes of municipalities, so this is in keeping with the other bills we've passed on this for other municipalities.
I'm sorry, I didn't address that, Mr. Chairman. The Dush bill addresses second-class township.
Yeah.
The second-class township.
And we've already done third class, my bill.
Yes,
And then-
we have borough bills in the process.
Yep.
Act 3, under your name, addressed cities, third-class cities.
And I think we passed Representative James's bill out of committee before.
That's correct,
So
yes.
it's in the
Representative
Senate.
James's bill is in the Senate, and that addresses boroughs.
Thank you. Seeing no further questions, we'll take a voice vote on both bills. We're voting them as a package, if that's okay with everyone. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Motion carries unanimously. Both bills will be reported to the House for consideration. Representative Siegel has been extremely patient. We unfortunately have run out of time. There is the likelihood of us having another meeting on June 5th, which is coming up after the holiday. So at that time, we're planning to allow Mr. Siegel to please give an overview of his legislation and get consideration on his bills as well. That being said, if there's no other further business before the committee, this committee stands adjourned.